Good evening, members, officers and members of the public. Welcome to Tendring District Council Planning Committee on Tuesday the 10th of September 2024. This committee meeting is being broadcast live. It is also being recorded. The link to the live stream can be found on the Council's website www.tenderingdc.gov.uk/live meetings. For the purpose of the recording, I will introduce everyone. I'm Councillor Maria Fowler and I am the Chairman of the Planning Committee, and I will introduce members of the committee separately. Councillor Maurice Alexander.
Good evening, Chairman.
Councillor Richard Everett.
Evening, Chair.
Councillor Bernard Goldman.
Good evening, Chair.
Councillor Adrian Smith.
Good evening, Chair.
Councillor Geeta Sudra.
Good evening, Chair.
Councillor Anne Wiggins.
Good evening, Chair.
And Councillor John White, my Vice Chairman.
Good evening, Chairman.
The officers assisting us this evening are from Committee Services, Bethany Jones, and from Leadership Support, Maddie Adgar. Planning Officers, Michael Pingram, Planning Manager, John Pateman G, and our Planning Solicitor, Mrs. Joanne Fisher. There are no changes to the running order this evening. The application will be presented by the officer, followed by public speaking in the order of the applicant or agent, any members of the public who have already asked to speak for or against the application, then the speaker from the town or parish council, and finally the ward councillor. Members of the committee will then have the chance to question the officer. Once all the questions are answered, the committee will then debate. When all the points are discussed, finally the chairman will ask if we have a resolution and will then call for a proposer and a seconder, and the committee will then vote according to the normal rules. Item 1 on the agenda, apologies for absence and substitutions. Councillor Everett.
There were two officers that weren't introduced, and I think it might be useful for members of the public to know who they were.
Thank you, Councillor Everett. There are indeed two officers in the room. Our Chief Executive, Mr. Ian Davidson, and also sitting over the back there, Mr. Keith Simmons. And there is an officer there that actually, I have to be honest, I don't even know who you are. I don't. Christopher Bailey, so there you go. So, no, I didn't know that's who you were. So, there we go. Have I missed anybody else? Thank you, Richard. Thank you. Item 1 on the agenda, apologies for absence.
Thank you, Chair. I have received apologies from Councillor McWilliams with no substitution.
Thank you, Bethany. Item 2, minutes of the last meeting. Members, those of you that attended the last meeting, have you all had a chance to review the minutes? Are there any amendments? May I have a proposer, please? Councillor Maurice Alexander proposed, seconded by Councillor Geeta Sudra. Are you all in favour, those who were in attendance at the last meeting? Thank you. Item 3 on the agenda, declarations of interest. Are there any members? I have a declaration of interest. Item 5 on the agenda, planning application A1 23/01757/FUL 610 Main Road, Harwich. I am the ward member for Dovercourt All Saints Ward, and I am predetermined on this application. Therefore, I will withdraw from the committee and take no part in this application. and I will hand over to my Vice Chair, Councillor White. I've skipped an item. Not enough sugar in my tea. Item 4, questions on notice pursuant to Council Procedure Rule 38. Are there any, Bethany?
Thank you, Chair. No, there are no questions.
Thank you very much. I will now hand over to Councillor White, and I will be returning to close the meeting, so I shall see you all later.
Right. Good evening. You're already been welcomed, so we can move straight into agenda item 5. That's A1 Planning Application 23/01757 full. This is at 610 Main Road, Harwich, and I'm going to straight away invite Mr. Pegram to introduce it.
Thank you, Chairman, and good evening, members. Yep, so the application site is 610 Main Road in Harwich. It's on the northern section of Main Road within the parish of Harwich. The application seeks full planning permission for the change of use of the property from a dance studio to a mosque community centre. As part of the proposal, external works include the erection of a pergola to the eastern side of the building over the side access and the installation of a rear elevation window at ground floor level. So I'll just do the usual with my presentations just to sort of highlight the surrounding area. I note that the screen keeps flickering in and out, so apologies for that, but hopefully it will sort of maintain. So here's the application site highlighted in red just here. And if we look on the sort of Google image here, we can see the wider surrounding area. It's relatively urban in character. There's the cemetery just over to the northwest here. There's a mixture of residential and commercial properties all around. The existing building is a single-storey property, previously used as a dance studio, but currently vacant. The site does fall within the settlement development boundary for for Harwich, within the adopted local plan. And approximately 100 metres to the east is a Grade 2 star listed building. To the south and west of additional Grade 2 listed buildings. So I'll just run through some photos of the site. Obviously we all visited there this morning, but this is the front entrance of the site here, and you can still see the signage from the former dance studio. There's a side access just running along that part there. Here's another shot from the front. Okay, sorry, one second. Is it that one? Yeah, it's fine. Right, so this is the front of the site, and next door you can see a commercial property just sort of further on in the image. This is just the other side, and in the distance there you can see the fish and chip shop, and also the front of the site just dominating that photo. Here's just an element of the rear of the site. We all noted from our visit this morning that it's largely overgrown now in comparison to what we're seeing in this image. This was taken a number of months ago. So this is the existing and proposed block plan. There's very little difference, actually. The main external alteration is the addition of the pergola to the side of the property, just to the south here, but otherwise they're basically the same image. This is an image of the existing and proposed front elevation. Again, the pergola on the side there, but otherwise no changes. The rear elevation existing at the top and at the bottom the proposed, and you'll just see there's just one additional set of windows at the ground floor level, otherwise exactly the same. And this is just a 3D image that I felt would sort of show the pergola a little bit clearer for you, and you can just see it on the side there. And oh, right, sorry, yeah, I didn't realise that one was. Sorry about that. Okay, yeah, and then this final image here is just the existing and proposed ground floor layout plans. Again, they're very, very similar. Just the addition of the ground floor window just to serve that main hall, but otherwise it's pretty much exactly the same. So, yeah, so to run through the assessment of the application in terms of the principle of development, the application is seeking permission to change the use of the site into a mosque community centre, and it will not result in the loss of an existing community facility. The submission outlines that there will be a range of community facilities proposed, which includes weekly prayers, educational workshops, and youth programmes. These all fully align with the requirements of local and national planning policies. Officers do note that the current site is vacant and has been since 2023, but given that the site is currently vacant, the proposal would actually bring back into use a community facility, and therefore for those reasons the principle of development is considered to be acceptable. The building is highly prominent from views along Main Road. However, officers note on this occasion that the development is predominantly just a change of use, just the small external alterations that I've discussed. Whilst the pergola will be visible from the street scene, it is relatively a minor addition, and it will not harm the character and appearance of the area. The proposal is in proximity to various listed buildings, and as such our colleagues at Essex County Council Place Services Heritage have been consulted. They raised no objections, but they did request that previously on the front elevation it was to be clad in timber, but they recommended that this was not to be installed. Therefore, during the determination of this application, revised plans were provided that remove this, and it's to remain as existing. So no objections therefore raised from a heritage perspective. Essex Highways Authority have been consulted. Initially they requested additional information relating to the off-street parking provision and the approximate number of visitors that would be expected, as well as a car parking survey to determine whether there is enough on-street parking to cater for the proposal. Following these comments, the agent for the application has provided a travel plan document outlining the expected weekly attendees for both weekly prayer and the various additional community activities, and it ranges between approximately 6 to 15 users for each session. It is expected that the number of users attending each session will range between 1 and 3, with there being alternative options including like walking or the use of public transport. In total, weekly visitors are expected to be a maximum of 122. In addition, the travel plan does outline the usage associated with the previous use as a dance studio. The number of daily users would typically be in the region of approximately 75, of which 69 would use private vehicles. The total weekly figure for this existing baseline use was approximately 300. As such, it is demonstrated that the number of users is significantly lower with the use being proposed. So following receipt of this information, Essex Highways have confirmed that from a highway and transportation perspective, they do not raise any objections subject to conditions. Essex parking standards have not been updated since the introduction of the new use classes, and therefore do not specifically highlight the parking provision that would be required for the use classes being proposed. However, the equivalent use classes on the old standards would require parking provision of up to 15 spaces. On this occasion, officers acknowledge that the site does not have any parking provision. However, the existing lawful use of the site, which has of course been demonstrated to generate more users than that being proposed, equally had no parking provision. Given this, officers are content that it's been satisfactorily demonstrated that there will not be an additional impact to this baseline position, and potentially even a reduction in the level of usage. The site is also in a highly sustainable location, in good walking distance to public transport, and therefore, on balance, officers consider that the identified parking shortfall is not sufficient to warrant recommending a reason for refusal. In terms of the impact to neighbouring amenities, the proposal is predominantly a change of use, with the only alterations being predominantly the pergola. They're not considered to be significant or harm any existing amenities. With respect to potential noise disturbance, the use of the site is considered to be relatively low key, and a condition is recommended to restrict operating times. Given this, and that the use of the site is reduced in comparison to existing lawful use, officers do not consider there to be such harm that it would warrant justifying refusal. So in conclusion, this application seeks permission for the change of use of the building from a dance studio into a mosque community centre. Given that such a proposal retains a community facility to a building that's currently vacant, the principle of development is accepted. The proposal involves only minor external alterations, and following the submission of amended drawings to remove the proposed timber cladding, Essex Heritage raised no objections. Whilst there are neighbouring properties within the surrounding area, the external alterations and noise associated with the proposal are not considered to be harmful enough to justify refusal reason. Essex Highways did require additional information. However, following the receipt of this, they have raised no objections to the proposal. And whilst there is no parking provision, the significant weight is given to the existing lawful use of the site that generates more need for that parking, and that is the existing baseline position. So therefore, the application is considered to adhere with local and national plan policies and is recommended for approval. Members will also note that there is an update sheet where Councillor Henderson, who is one of the area's ward members, has confirmed she has no objection to the proposed development. We've also received one additional letter of support since the agenda was published. Thank you very much.
Thank you very much. Let us turn now to public speaking, and the first speaker is Mr. Azad Azora, if I have that right. If you'd like to come forward, sir, and get yourself established, and when you've got the microphone switched on, you touch the little face at the bottom and you'll find, and once you've got it live, so it's flicked off again, yet again, that's it. You've got 3 minutes, sir.
Good morning, everybody. Good evening, chairs, councillors, and members of the public. Let me introduce myself first of all. My name is Azad. I work for a company called Planning Beat, so my apologies for the yellow shirt, but my boss makes me wear that. I'm here today to support the application, which is a change of use for 610 Main Road from dance studio to a place of worship and community centre. Before submitting this application, we made a conscious effort to engage with the local residents. We held a community engagement meeting where we invited lots of local residents to attend. We listened to their concerns. One of the concerns they had is they thought they were going to lose a hall for hire. We reassured them that that is not going to be the case, and that was part of the application. There was other issues that they had in relation to the aesthetics, which the planning officer already touched upon in relation to the cladding. And again, we took those concerns on board, or should I say, my client took those concerns on board and changed the application accordingly. In relation to aspects of the community centre and itself, you can see what it's like politically at the moment, and there's lots of people, and I'd be doing a disservice by not mentioning the fact that when people hear a mosque is coming up in their local area, people raise their eyebrows and they make assumptions from, unfortunately, things they read and things they see. So a little bit about the applicant, which I think is important, and that is the applicant who sits behind me. He's a good friend of mine as well. We're from East London. Barking and Dagenham is the borough he works at, and he also works for a charity, and that charity is part of Barking and Dagenham Council as well, who supports that charity, and he's won an award, and he's also been recommended in relation to other things which Barking and Dagenham have been involved in because of his charity work. When I first spoke to him and I looked at the development, me being involved in planning, and I've been doing this for a long time, I came to the conclusion that it might be an opportunity to make some money, turn it into flats, and redevelop it. I won't go into his financial background, but let me tell you, he's not a developer and he's not a rich individual. But his commitment to the community is what's the forefront of this application, and he made it quite clear. I don't want to make money on this. He says, I won't go into the background of his family, but he wanted to do something for the community. His mother has got associations in this area, and he made a commitment that when she passed away, that he would do something. So instead of not listening to me and taking the opportunity of making money, which is what most developers would do, he took it upon himself to try to create a community centre and a place of worship. You can imagine there's not many Muslims in this borough, so there's not going to be a mass amount of people coming for the place of worship. So it's going to be a community hub which provides a number of services from youth programs, cultural events, services like the Hall for Hire itself. COVID itself has shown that charities play a supporting role in supporting local communities. Where there's a shortfall with council resources, charities step up. So whether it be a food bank, whether it be pleased to meet, have conversations, support services, psychological services, youth services, these are all aspects of services that he's already providing in Barking and Dagenham, and he wants to extend it to this borough.
Could you wind up?
Yeah, so all I wanted to mention is the traffic. You can see the traffic officer supports the application, and along with the planning officer. Thanks for your time and your consideration. If there's any questions, I'm more than happy to answer them.
Thank you very much, sir. In this procedure, we don't have questions, but I think you've answered some of our questions that we might have put to you anyhow. Right, the next speaker should be a member of the public. We haven't got anybody there. We have a member of the public speaking against the application, Mrs. Christina Richardson. Mrs. Richardson, if you'd like to come forward, and as you've been here before, I understand, you know you also have 3 minutes. Thank you.
Aha, thank you. Memory's not good, obviously. Right. Individuals have the right to follow a religion or faith at a place and time of their choosing, and I believe it would be discriminatory under the Equality Act for conditions to be set as part of the planning process when the building is in use as a mosque. Realistically, the frequency of prayer times may change, and any amendments will be determined only by its senior members. Previously, councillors approved an application for the Upper Dovercourt Social Club Community Centre with rear building for hire at 618. Issues raised then are relevant today. Noise, access by emergency services, questionable need for another community centre, increased numbers of people congregating in the immediate residential area, and parking. Is there a need for yet another community centre? Who will be responsible for managing potential issues over noise, parking, use of the building, and so on? Drawings show a roofed pergola to the side and open to the road. When not used by attendees of the mosque, it may have to become a covered smoking area for individuals visiting the community centre. I'm unaware of any designated provision in the submitted drawings. On open day, I was assured of less intensity over parking than when the dance studio was open. Open or closed, there were and only are 20 parking spaces at this end of the road. Irrespective of who or why a person parks, it's first come, first served. Availability is determined by opening times of the social club and its activities, and the rear building when hired out, the Trafalgar pub opening times and social events, customers accessing the 2 takeaways, resident parking, school pick-up and drop-off, and services and funerals held at All Saints Church close by. Drivers can also find the road blocked by beer delivery lorries. I was reliably informed when the studio was open post-COVID that habits changed. Instead of the adults staying to watch, children were dropped off and picked up. This could mean short-term parking across driveways or overspill onto Main Road. So whether the studio was open or is now closed and operational elsewhere, There is no more or less available parking. I believe the parking statistics in the TRD travel plan report to be inaccurate and do not demonstrate past or likely future demand. Essex Highways desktop assessment says that 610 is near to an existing pub and 2 takeaways with no off-street parking. However, it fails to identify an insurance company which has a small customer-only car park and the social club and building for hire, which I've mentioned earlier. Both have no parking provision. Also not mentioned are 2 previously approved new builds currently up for sale. These form a terrace with 7 more homes. All 9 front doors open directly onto Main Road. Access for parking to their rear is prohibited by common land. Same also to the rear of a detached house, and access to the front is impossible for road safety reasons. Residents with cars park where they can. I believe there is intention for land to the rear of 610 to provide parking for up to 15 cars with application for a dropped curb. In my view, there is insufficient space for cars to manoeuvre safely. A dropped curb removes 1 to 2 road parking spaces, and a car park creates more noise for residents living behind. The issue is location. It is location. Given the concerns raised during a previous application, which remain relevant today, the road parking needs of residents, existing businesses, and recently passed planning applications, I believe approval would be counterproductive, as any benefits would be outweighed by an adverse impact upon the local community. Thank you.
Thank you very much, Mrs. Richardson. I was just going to remind you you'd slightly overstretched, so that's splendid. Thank you. We've heard one from Councillor tonight saying that she had predetermined ideas, and that is my chairman, who has left the room, and the other ward councillor has no objection. So that sums up those. In which case, colleagues, we have finished the speakers, in which case it's now questions to the officer. Have anybody who's going to raise any questions to Mr. Pegram? Mr. Everett. Oh, Councillor Everett, I beg your pardon.
Thank you, Chair. I asked the officer at the meeting this morning whether the blue line around the application and the red line were coterminous or not. He said he was going to get back to us at this meeting. He hasn't brought it up, so over to him.
Thank you. Yeah, so this image here just shows the red line drawing, and for everybody's benefit, on the site this morning, the applicant did suggest that it was unclear who might own the land to the rear, but as part of the submission that we've got, this is the red line. There's no blue line on the plans that have been submitted.
So the red line we're clear about. We're not clear about the blue line, because when we looked at the site, the wooden fence at the end was further down than where the red line would be.
If I might, ultimately, in planning terms, that screen going off is very annoying, isn't it? Ultimately, the application is submitted in respect of the red line plan. The red line plan is the defined area of the application to be determined, and any blue line is kind of additional bonus information. It tells you if they own other land within the location plan that you're provided. It is offered up as in, this is also land we own elsewhere. But ultimately, the application itself is only determined on the red line area itself. In this case, looking at the two, I would certainly say that the perceived rear area here is obviously larger than where the red line is shown to be, but the red line is only any change of use will only be to the red line area. That is the application site for determination. So if it's smaller, but it's probably about half of that land by the looks of it.
Which leads me on to another angle. The possibility of the fact that the ownership actually goes much further back is still a planning concern. That's why we have a blue line on them, so that we know and are informed as a committee where other ownership is. It may not be directly relevant to the red line boundary, but I'm not sure where things actually start and begin, and so that's a concern.
Any further questions? As usual, the IT is playing up again, but it seems to be all right now. Right, further questions from members? If not, I'll go back to Councillor Everett.
The answer to my first question is partly relevant to what I'm going to ask now as well. In terms of parking provision, we've been told that under normal circumstances you would expect a parking provision of around about 14 spaces for a development such as this. It is clear, at least from the situation with the space at the back, that actually parking could be afforded on the site if it were required to be so. So the situation with parking and the adverse effect on parking outside the site could actually be very easily dealt with on site. What are the comments from officers on that?
I'll just see if the officer wants to comment on it. Or
Thank
I'll
you.
take it just as a statement that you have made. Officer?
Yeah.
Yes.
Sorry. Ultimately, the application has to be determined on the merits presented. It is not proposing parking to the rear of this property, so that is not for your consideration. So therefore, your consideration is an application that does not propose parking. I also don't have that within the realms of this application to determine in any event, because it's outside, well, half of it is outside of the red line. We understand there might be a future consideration, but that is obviously not for the determination of this application, and it's not before us.
And are there any plans that the council or officers are aware of for parking provision in the future?
As I said, there might be, but it's not a guarantee, and therefore on that basis it's not something you can consider or determine.
But obviously we could refuse on the basis that there was inadequate parking provision.
That is in your gift as the decision maker. If you decide that this application has inadequate parking, it is a valid planning reason, but of course your officers have provided you material considerations in respect of the historic use of the property, and of course the highway considerations. As per your report, you would need to balance all things.
Thank you, that's clear.
Councillor, I think if you could just give us a break. Councillor Alexander.
Thank you, Chair, but I'm more than happy to give way to Councillor Everett to allow him to finish, as I may be able to take something from his questioning.
Thanks, Councillor Alexander. I naively thought that the purpose of planning was to improve the district. It seems to me that in this particular case, not only are we not improving it, we're actually making the situation worse because of parking provision that does not meet the basic standards that you would expect in Essex. Can you reassure me that actually planning is trying to get a better position rather than a worse position?
Thank you. Yeah, with this one, I mean, it's outlined at paragraph 8.24 of the report. But essentially, the parking provision, you're right, there's no parking provisions part of this. And in an ideal world, yes, we'd want parking. But where we've fallen is that the existing baseline use as a dance studio equally has no parking. But it has been demonstrated that that had a much higher usage in terms of vehicular movements and parking requirements than what that being proposed is. So I suppose in some ways it's kind of a neutral impact, but it's certainly not a worse position, in our view at least, it's not a worse position than where the lawful use of the site as a dance studio is. It's a neutral impact. That there's no parking provision for either, but there is actually less need for parking with the current proposal. So given that, and that the site is in a sustainable location with a bus stop and in really close walking distance, we consider on balance that the lack of parking is acceptable. Of course, members may come to a different judgment on that, but that is where officers have fallen on this particular issue.
Councillor Alexander.
Thank you, Chair. Am I correct in thinking that the movement of traffic anticipated by the coming of the mosque is in fact half or less than half of what was anticipated when it was a dance studio?
Yeah, those figures are kind of accurate. The expected weekly visitors with the current, with the proposed use is 122, and the existing lawful use as a dance studio generated movements of approximately 300. So that's the figures that we have. So yeah, a little bit more than half.
Councillor Everett, my colleague now, quite rightly pointed out, within the planning scope, it must be an improvement to our community. But looking at the building that we saw today, am I right in thinking that it is in a poor state and in need of much TLC? Well, use that word, I like that, TLC. And TLC to return it to any form of workable and acceptable building in our society today.
Sorry, I'm not too sure what the question was. You're just saying, sorry.
The windows, for example, overgrown gardens along the side is in need of urgent attention. All of this which was identified by the developer at the time and was made quite clear and abundantly clear to us that all this would be repaired over the space of time and developing it into a mosque should it get permission.
I guess all I can say to that really is like repair works and clearing of the site, that kind of thing, that wouldn't require planning permission, so it's not part of this application. I would assume that it would be in the applicant's best interest to maintain and clear the site, etc. You know, to improve the visual image of the site. But as part of the proposals, the only external changes are the pergola to the side of the property and the additional rear windows at the ground floor. To the rear elevation.
Chair? Okay, so going this far, I'm pretty sure that the developer would be prepared, if need be, to place another application in for the ancillary work to be carried out within the curtilage of the area. And also, am I right in thinking that being done and that work being on the back burner, that would be an improvement to this building and therefore would be an improvement to the community?
So, we concentrated on highways earlier, but of course you could argue there's a very long list of changes here that you could, arguably, depending on your point of view, consider to be an improvement. You are looking at a change from a commercial venture of a dance studio through to a community use under Class F. So you have an automatic point that is now for the local community rather than a commercial venture. You have the fact that you're going to have a building brought back into use rather than vacant and neglected, something that I'm sure would be managed and maintained, repaired, weeded, and so on. You have those improvements. You are also in a sustainable location. How far do you take improvements? Ultimately, though, planning has a range of roles. Yes, improvement in some cases is part of that, but avoidance of harm is the other part of that balance to be taken. And your officers have concluded to you that they do not foresee there to be any demonstration of harm that would warrant refusal that would be defendable at appeal, and that is the presented item to you.
Thank you, Chair.
Right, thank you. Now, we have 4 other councillors with no questions from them at the present moment. I do have one, Councillor Suda. Thank you. Could you use your microphone, please?
I refer to 8.22, and that's to do with the travel plan. Just need a bit of elaboration on the last sentence. Should planning permission be forthcoming, a condition can be included to secure full details of this prior to first occupation of the building. What does that involve?
Thank you. Yeah, so condition 4 of the recommendation is requiring the submission of a travel plan with details of travel arrangements to and from the site for employees, customers, etc. And that would be prior to the first occupation use of the development. The travel plan document that we've been provided has included some potential details of what could be incorporated. An example might be taken from the travel plan. Examples include like posters on notice boards that sort of advertise the public transport options available to people, trying to facilitate shared car usage where possible, the hiring of a travel plan coordinator, travel forum meetings, that kind of thing. So they're the sort of details that we'd probably expect within a future document that's submitted as part of that condition.
That's great, thank you.
Any further questions? Yes, Councillor Everett.
I've gone through the application form in detail, as I always do, and a couple of questions come out of that. The first one is that in the application, foul drainage, that it was said to be unknown as to how the arrangements would be for the site. That would normally trigger a foul drainage assessment under our procedures. What does that foul drainage assessment say, please?
Yeah, this is something we'd have to check, to be fair. Ultimately, this is an existing building. It's not a new building in the countryside or elsewhere. So I wouldn't normally consider that would apply. But I think it's reasonable to assume that being in a town, being in a built-up area such as this, that existing drainage of the dance club facilities would have applied, and therefore would apply again to this, which is only for change of use, not works, apart from the side extension element. If councillors are looking for reassurance on this issue, there is no reason why we couldn't impose a condition to say it shall be into the existing drainage facilities, or indeed for us to agree that separately if reassurance is necessary.
Thank you for that. I'm glad the Chief Executive is here to this. This is the third time that this has happened within this year, where foul drainage assessments have not been produced when they should have been, and it has been raised by this committee twice before. So I'm not impressed with the fact that yet again officers have actually managed to ignore their own rules in terms of foul drainage assessment, and I will leave it there.
Yes.
I think if I can repeat myself from previously, your policy may require it, but the requirements for validation don't, and it is ultimately up to the applicant to provide as necessary if they feel they wish to. And I'll leave that there as well, and it might be something we need to take away and have a further discussion about.
And as you know, this committee has espoused on that issue before that it would like it to be done.
I think you've both agreed now we'll drop that particular subject and can move on. Other councillors, what have we got on further subjects or queries at this time? If there's nothing forthcoming, I'm going to invite you to... There is Councillor Everett wants to get back in with another one. Yes, Councillor Everett.
I mentioned that there was a second one on the form. Land which is known to be contaminated, it says no. Land where contamination is suspected for all or part of the site, no. A proposal that would be particularly vulnerable to the presence of contamination, no. Those were the answers in the thing. Now, I'm trying to go back in terms of probably 50, 60 years. What was the site used for before it became this building? Because my understanding is that that would have all been farmland where pigs could have been raised and slaughtered, etc. So what was the previous use before the current use of the building?
The officer will answer that, but as far as I'm concerned, this is a change of use from something which has got permission already. What it did 50, 60 years ago, you're probably right, it probably was farmland, but we are talking about a change of use from an existing premises.
Thank you, Chairman. Yeah, we're just looking at old mapping, and between 1888 and 1915, we've got an image, and it looks like just open agricultural land. In answer to that question.
So that was agricultural, not...
In fairness, it's just a blank space on an old map, so it's between buildings, and it's a very long paddock or very long meadow alongside, obviously, where the public footpath historically has been as well. That's all we can tell you, and you know, planning only goes back to 1947, so we can't go back further than that.
Very much for that. Next issue I want to move on to is in terms of noise. The mosque will be used particularly on Fridays, but is it going to be used for prayer at other times of the day and week? And what happens during festival times in terms of usage?
again, we don't know how they manage their time in the hours they have is ultimately their choice of how they run their. I was about to say business, but it's not business. It's their facilities there. Ultimately, we feel that it is adequate in planning terms to mitigate any antisocial time frame, which is why you have a condition imposed which hasn't been imposed before. The dance club had no such restriction, but this time round we have this opportunity to make an improvement in planning terms, in our view, and we've imposed a condition to control the hours as per set out in your papers. But what they do within those hours is obviously going to be varied and would be unreasonable to control to the exact time frame.
Thank you, that's useful. In terms of normal practice for planning applications, would we improve an application by adding something to it that the developer hadn't thought of?
Sorry, can you repeat the question? I didn't quite catch it.
As a planning officer, would you seek to improve an application that the applicant had provided? Say, for instance, they put timescales, would you actually add wider timescales?
Speaking as a planner, in my previous life before I became the head of planning, ultimately my aim as a planning officer was to seek any opportunity to create a better place, a better design, a better layout, and I would negotiate with the applicant accordingly. But ultimately, if you get to the point where they are wanting you to decide their application, which you have to judge on the merits provided, you then have to make the decision of whether or not it causes harm to warrant refusal, and have you got, dealt with all of the issues that may be a burden to the local community. Ultimately, you have to take into account all material considerations. That includes your local plan, that includes historic uses and planning uses that have been agreed before, and all of that comes down to the planning balance. This really isn't a question for me. This is a question that is your considerations and your judgment as the committee and decision maker in this case.
And in terms of that, in 8.6, the opening hours proposed by the applicant were Mondays to Thursdays 2 p.m. to 8 p.m, and Fridays and Saturdays 12 p.m. to 2:30 p.m. and 4 p.m. to 9 p.m. Is that correct?
I'd need to double check the application form, but from memory that does sound reasonably accurate, yes.
So in the conditions, we have the hereby permitted development use shall only operate between the hours of 11 a.m. and 9 p.m. Mondays to Sundays. So Sundays weren't asked for by the applicant, and that length of time wasn't asked for by the applicant. Comments?
Yes, because ultimately you have to balance what is reasonable to impose as a planning condition. You have to pass the tests of the planning conditions. Is it necessary? Is it reasonable? Is it related to the development and so on? In this case, we still as planning officers need to bear in mind that the existing dance studio commercial use is an unrestricted use in terms of hours. Its noise, its number of people, its number of cars could be any time, any day of the week. You could actually argue it the opposite way round. It is completely unreasonable for us to restrict the hours of this proposal in its entirety, and that might be a challenge that the applicant we're taking a risk over could challenge us to say, you're reducing my available hours compared to the historic use of this site, which has never, to my knowledge, caused harm, and therefore why are you unreasonably restricting my hours to the hours set? Now, we think there's a balance here, and the balance is the hours that we've proposed, which are more than the applicant has stated. So in theory, we will never have any conflict over those hours in terms of that planning condition. But on the other hand, It could be completely argued the other way, and that condition could be argued to be unnecessary if I was pushed on that point.
So we as a committee could decide different hours, could we?
Yes, you could. That is in the gift to you as the decision maker. You would also need to apply reasonable tests and considerations to that decision.
Thank you. So presumably if we could do that for hours, we could do that for numbers of people on the site as well.
If I can come back, Chair, sorry, I've been missing you here. You could, but then you also need to consider how reasonable you are being in the operation of the site and how that may affect how the site may operate and whether you're being, I could just leave it as unreasonable or not. So the more we tamper, the more risk you perhaps get into. But maybe Joanne can help me out a little bit more on that. Thank you.
I was just going to invite the solicitor to help us.
Thank you, Chair. It was just really to remind members of paragraph 56 of the NPPF, which says that planning conditions, which is what John is referring to. So it's planning conditions should be kept to a minimum and only imposed where they are necessary, relevant to planning and to the development to be permitted, enforceable, precise and reasonable in all other respects. So that's what John is referring to when he's talking about reasonableness in imposing conditions on grants of planning permission. So just members need to bear that in mind when they're thinking about what conditions should be imposed and whether any conditions ought to be amended to the ones recommended.
Thank you for that. It's really helpful.
Councillor Everett, I think you've had a fair crack of questions. I'm going to say now that we will now debate the object and see where we go from there. Councillor Alexander.
Thank you, Chair. Sorry, Councillor Everett, last thing I wish to do is to cut you off midstream, but I'm a little concerned by some of the issues that are raised here. Noise. Are we saying that a mosque with, I believe the figures that were rolled around today with the officer on the site visit was 16 plus, against the noise that would have been accumulated with a group of children and maybe young adults and indeed older folk playing music to dance with. And yet I've heard no complaint from anyone about the previous noise. We've heard about the previous parking, but we never heard anything about the noise. And it was my understanding, taking my own religion into consideration, that these are places of quiet prayer. That's, would you give me some pointer on that? Am I right on this, do you think?
Thank you. Yeah, under the impact to residential amenity section of my report, paragraph 8.28 and 2.9, we sort of discussed the sort of potential impacts that it might generate. So in terms of noise, we've come to the conclusion, similar in terms of what you sort of suggest in terms of vehicular movement, same sort of approach really, that the current existing lawful use is likely to probably generate a slightly bit more noise than what's being proposed. But as an aside, we're essentially concluding that the use overall is of a low-key nature, countering the fact that the vehicular movements is going to be a reduction, countering the fact that we've got the existing baseline use that could be operated regardless of the determination of this application. And we come to a conclusion that actually the noise disturbance, as well as, adding in the condition about restricting the operating times, the combination of all those factors is we consider that the noise impacts and general impacts to neighbours as well are not going to be so significant that we would recommend a reason for refusal.
Debate, Councillor.
Right. So the call to prayer, that is a fixture in most mosques, in fact all mosques, happens usually over loudspeakers and is internal to the building initially, and in fact one part of the call to prayer is internal, but one part is external. So the noise that can be produced by that could happen from any times from 3:30 in the morning till 11 o'clock at night. Are we content that the hours of operation will stop any external noise from waking up residents locally?
Two things there. One thing, yes, the hours of operation is hours of operation. That means all parts of the operation. That would include any use of speakers on that site outside of those hours. I think we need to be very clear about what we're actually discussing here, and I think we're coming off track a little bit. And if I may just be very clear with this. We've actually put a condition in the recommendation for this purpose, and you'll see that it says that there shall be no other use except for class F1A, F1F, F2B. They are, just to be clear, education. That's the first one. F1F is public worship or religious instruction in connection with such use. And the final one, F2B, got that one, is halls or meeting places for the principal use of the local community. That is the proposal before you. And obviously the proposal, or should I say the existing use at this moment in time, would be defined as Class E. And actually there could be quite a conversation about what that existing use is. You could define that it's only ED, which is indoor sport, recreational fitness, but it could also be argued to be sales of retail. It could also arguably to be office use, day nursery, medical health centre, and other things within Class E, because things can move around within Class E if it is not restricted. So that dance studio is a dance studio, but actually could tomorrow, without needing us involved, become a range of other uses within Class E. So what we are doing here is restricting it to a community use in terms of education, in terms of worship, in terms of public meeting hall. That's it. So just to describe to exactly what you're determining here, I'm going to give you an example of my past life of being a planning officer. At the end of the day, there's two nightclubs in a town. One nightclub everybody loves because it's managed really well. The other nightclub they all hate because of the noise, disturbance and all the other issues, and they're right next door to each other. Ultimately, unfortunately, planning can only go so far before it becomes the management of people and how they manage a place, and we can only have so much influence over that, no matter how many conditions you throw at it. I'll leave it there.
Councillor Alexander was indicating, I think. Did you?
Are we in debate?
Let's go into debate.
Ah, excellent. Right. To me, the application is robust enough for me to make a decision that is based upon what I've heard tonight and listening to the officer and the excellencies by which he's produced and delivered this agenda for us. We've heard tonight from our lady speaker that we live within that multicultural society and we must uphold the rights of people to be able to freely worship in their own way. That being said, we spoke about parking. Well, for those, well, I was unenlightened, I've got to be perfectly frank, and I base this upon, again, my own religion. And investigation has shown this, which came up. And the following, Chair, if I may. With your permission, is coming to the mosque on foot is better than coming by car because the reward for your steps will be counted for you. In other words, I took some advice on this from my own mosque and education centre in Pier Avenue. And what it means is that you're encouraged to walk, unless of course you're unable to walk. You're encouraged to walk to the mosque because that is how you count for yourself. Now, I may have got this slightly wrong, but I don't think I have. I'm looking at this application and the difficulties it has been to put this together. At the moment, it's a tatty-looking building that is destined to be made a far brighter and nicer place. Irrelevant to how many applications are going to be required, I'm assured that they will come in eventually and it will all be done properly. I'm a little concerned about the beautiful prunus that is at the bottom of the garden, a cherry tree, but I've been assured that the cherry tree will remain and it won't be touched because the actual owner of the building likes that as well. That satisfies me as well. So, at this point, I see no logical reason to argue with the decisions that are made by the officers, and I've listened carefully to the debate, and I would like to recommend approval on this application.
Thank you very much. Other councillors? Are we going to get... Yes, Councillor Sudra.
Yeah, I'm happy to second that. I think I'm quite happy with the discussion around parking, etc. And yeah, I think there's provisions that can be put in place to improve that.
I'm concerned over the amenity of local people, and particularly if there is an expansion of numbers, if this becomes a popular venue, because the parking provision now is inadequate, and it would be even more inadequate were it to become highly popular. Now, the applicant has suggested that there'll be a maximum of 15 worshippers at any one time. So I think I would like to seek that to be included in any condition given with the application. So not to permit the mosque to be attended by more than 15 people at any one time for the purposes of religious worship.
Would you like to comment on that, Mr.
I do.
Mayor?
I'm just trying to think of the best wording. I think it's totally unreasonable to dictate the number of worshippers. And I don't think you would find us doing that for other uses or other religions. I think we need to be very careful here. Ultimately, you have a red line plan, you have a site area, you have a building that restricts the numbers by default, other means to restrict numbers, which probably include insurance. I think you need to consider that the previous use was unrestricted in numbers and could be highly popular or more popular than it was. And that is the worst case scenario we have to kind of work back to as a default. I think you need to be very, very careful. And if you were to go down that road, I would seek separate legal advice on that issue.
And we'll ask the solicitor to add something.
Thank you, Chair. So I've already referred to the NPPF in terms of reasonableness of imposing conditions and the requirements and the things that need to be thought about in order to do that. But just on the highways point, I just wanted to point out also paragraph 115 of the NPPF, which says that development should only be prevented or refused if that's, if you find the condition you don't oppose condition, you're thinking about refusal on highways grounds. It's just a reminder to members that development should only be prevented or refused on highways grounds if there would be an unacceptable impact on highway safety or the residual cumulative impacts on the road network would be severe. And also, as members know, to rely on reasons for refusals, they need to stand up to scrutiny on the planning merits of the case. So it's just a reminder of those considerations that you need to think about when you're making the decision, and if you're concerned about highways, and you know, to weigh up everything that's also mentioned by officers in their report.
Thankfully, Justice Lang of the Planning Court doesn't agree with you. Justice Lang, in the case Khalid Ikram versus Secretary of State for Communities and Local Government in 2019, held that the condition not to permit the mosque to be attended by more than, in this particular case, 30 people at any one time for the purposes of religious worship was a reasonable condition. So, given that the High Court thinks that, why do our officers think that perhaps they know better?
Because you are not approving a mosque, you are approving a variation of uses. This includes a meeting hall for the local community. You could put a condition there that says anyone worshipping is limited in number, but if they're not there worshipping, there could be any number. The enforceability of that condition would be very questionable. I can think of other reasons, but I think you're going down a very dubious step here when you don't have any other evidence that says that harm would be created if that condition was not imposed. You are not giving me any evidence of harm to justify a condition such as that. Obviously, the proposer and seconder would have to agree with any condition you might wish to offer.
I remind you, it says on here the development is change of use from a dance studio to a mosque community centre.
Yes, Joanne?
Thank you. I haven't had the benefit of looking at the case. Cases are often decided on their own facts, as you know, so I don't know the facts of that particular case and the circumstances. The matter that members need to consider today is, in this particular case, as John has highlighted, we need to identify if there's harm. So if there is harm, then conditions can be imposed to mitigate that harm before permission is, granted. So that's the purpose of a condition, and it has to be reasonable, etc., as we've already been, as I've already explained. So I think what members need to consider is whether or not they feel that harm has been identified if the mosque were to, and the use were to proceed, or permission be granted for the use, whether there would be harm, and that take you back to paragraph 115 of the NPPF, which says that development should only be prevented or refused on highways grounds if there would be an unacceptable impact on highway safety or the residual cumulative impacts on the road network would be severe. So I think as members you need to consider all of the evidence in this case and all of the facts of this particular case, and decide whether you feel that there would be harm or sufficient harm to refuse, or sufficient harm for you to impose that restrictive condition.
Right. Now, I have a proposal and I have a seconder. I have still got 3 councillors who haven't spoken, but presumably they are happy with what they've heard to date. And unless we go any further, I'm going to take this proposition. It was proposed by Councillor Alexander and seconded by Councillor Sudra, and I am reminded that we need to vote by a show of hands, those in favour and those against. So, yes, I'm tempted to weaken and grant but I have already said that we will do a proposal. So I would suggest, Councillor Everett, that the way, if you wanted further items in, would be to oppose the proposition and then put in a suggestion. So I'm going to take the vote.
Or put an amendment.
Or I would take an amendment if, but it's got to be agreed with the proposer and the seconder.
That's how amendments
before
work.
It becomes a substantive motion.
I would like to propose the amendment that the condition I referred to, not to permit the mosque to be attended by more than 15 people at any one time for the purposes of religious worship, is put. I don't know whether I'll get a seconder.
Yes, I will go with that, but I haven't got a seconder for that as an amendment. So, Councillor Alexander, are you happy with that as the proposer?
No.
Right. And Councillor Sudra? No, also. So we won't take it, and we'll go into a straight vote. Those in favour, as shown on page 20 of approval, please show. That is 1, 2, 3, 4, 5, 6 in favour, and those against, Councillor Everett. That proposal is accepted. Thank you very much.
Can I have that recorded, please?
And that, ladies and gentlemen, yes, will be the end of that particular application. It is granted. And I'm going to call the chairman back so that she can close the meeting officially.
Thank you, Councillor White. Before I close this meeting, I would just like to apologise to those who were viewing the live stream for the sound. There were some problems with the sound. Hopefully we'll get those technical difficulties sorted out in time for the next meeting. So thank you all, and